Okay, Ellen, you ready? Recording is on. Welcome, everybody. Welcome to this version of HSX University, and the topic for today is the Cures Act, which has been rolling out in steps and steps and steps, and there are two major deadlines coming up in a few months, and today the topic will be increased access to electronic health information. Are you ready for these next steps in the Cures Act? Speakers today, I'm very honored and happy to have Helen Oczysławski participate with the webinar today. She's a healthcare attorney, founder and managing lawyer at the Oczysławski Law Firm. And I am Harm Sherbier. I'm the Chief Medical Information Officer at HSX. And this, if you Google the deadlines and the timelines for the Cures Act, this is the picture that you'll see. It's the timeline over the past several years. And it provides a really good roadmap for the webinar that we'll be providing for you today. On the top side, you see certification. So the deadlines on the top all have to do with certification of electronic health records. So they mostly apply, those dates and those deadlines mostly apply to EHR developers, the electronic health record developers, to the Epics and Cerners and the clinical works people in the world. They will have to fulfill those deadlines, but also for healthcare providers and hospitals and practices, because they are implementing and using that software. So the top part is about developers, but also for providers. The bottom part, information blocking, all applies to healthcare providers about their sharing of information. So the way we're going to do it today, Helen is going to start by discussing the bottom part of the slide, information blocking deadlines that are coming up, and then I will speak more about the top part, the certification deadlines, and how they apply to providers also. So with that, I think, Helen, I'm going to hand it off to you and would like to introduce you to start discussing information blocking deadlines that are coming up to us soon.
Absolutely. Okay, so big picture. Thanks, Harm, first of all, and welcome everybody to the presentation today. Many of you have been working on this for months at this point. As you all are well aware, the information blocking piece, the bottom piece, technically, that effective date has come and gone. A lot of what you can and cannot do, since we're talking about electronic health information, is very dependent upon what your IT, particularly your certified EHR vendors are doing as they catch up and meet their own deadlines with regard to the criteria that are changing as a condition of certification, which is that top part of that flow chart that Harm just referred to. So both parts are going to directly and indirectly affect both particularly clinicians and hospitals, as well as health IT developers. So I wanted to just take step back for a minute and take a big picture view of how ONC, the Office of National Coordinator, which is a particular federal agency that is implementing and pushing this. First, it was the electronic health record transition to EHRs. And now, of course, this next phase of push, which is the interoperability component of taking that digital data now and making it accessible. And the drivers of this with regard to clinicians and hospitals, and this is pulled right off, and for the most part, I believe that these slides will be made available to you in one way or another. You can see the sources, you can go to the sources. I will say that ONC has done a really great job in providing a lot of informational things for clinicians and hospitals, as well as IT developers. And so you'll find a lot of what you need there, to be honest with you. It's a matter of sometimes just digging through and reading it. So if we kind of step back, this nice little snapshot from ONC's website of what the Cures Act means and why we're going. And there are three sort of real drivers that they list out what it means for clinicians and hospitals with regard to implementation impact of the Cures Act, both on the certification and the information blocking. And first, the number one driver, and we've seen a little bit of this leading up through the HIPAA enforcement actions over the last few years with regard to patient access, right? They are really fixated and focused on making patient data requests easy and inexpensive, and allowing the patients to get access to their information in a fully automated, low-cost manner. They want patients and or their legal representatives to be able to access their health information from an app of their choice in a secure and standardized API way, and allowing that access to occur without special effort. Now, that's where we're going. For the most part, maybe some of you are already starting to experience some of that. The API, or what is referred to as the fully interoperable FHIR standards for API, where an app is essentially going to call up your EHR system, and the EHR system is going to go click and connect to it just like a fax machine or like a telephone, like we've done in the past. That's where we're going. We're not there yet. We've got about another year out where it's going to transition from optional and seeing it in a sporadic fashion, and having you say voluntarily adopt those things and implement those things as your technology allows you to do that, as it is technologically feasible for you to connect to such applications. But then we're going to, of course, transition over the next 18 months or so to where it becomes mandatory for your EHRs to support that. And so you're going to have no choice other than to allow those connections to occur in an automated way. And certainly the federal government, and particularly ONC, that's what they're looking for, and that's what they want. And so you can see the second bucket, they want to allow patients to have a choice of the apps. Clinicians, hospitals, and healthcare systems should be allowed to benefit. They're view it as a benefit to the vibrant app marketplace. This is straight from the ONC's description of that second bucket. The ONC Cures Act final rule calls for and mandates for open APIs, which encourages secure access to data for all these kinds of apps. And the final rule is intended to help ensure that those certified APIs are made available in a way that is safe, secure, affordable, and that the innovation in that realm and the marketplace is supported for health IT and app developers. So that is a policy and a goal of ONC to envision a world where those apps are going to be an integrated part of now the EHR and the healthcare marketplace in the future. The third bucket, in terms of what it means, is the implementation. Of course, the Cures Act has how do we implement this? Well, we're no longer going to allow EHR vendors to block information, to impose exorbitant interface fees that essentially make it practically impractical or impossible or unaffordable to create such connections. So we're removing all of that. That's why they passed this. They're making it illegal to engage in various practices that would constitute information blocking to allow for requesters to get at that information when it is otherwise legally permissible and supportable to do so. And last but not least, the impact is ONC views the final rule as striking a thoughtful balance between patient and clinician needs. They view it as encouraging transparency around patient safety issues with the health IT, while also attempting to protect intellectual property right of the health IT developers who may have made large investments in building the user interfaces and workflows. So the impact for health IT developers from a 30,000-foot view, they're going to be experiencing those API conditions of certification. You're no longer going to be able to have closed APIs. If you want to continue to be in this space, you want to continue servicing your healthcare providers and customers, you're going to have to follow those certification requirements, as I've already alluded to. That's going to slowly roll in to the point where it's going to be fully interoperable, where your EHR system is going to be required to connect to basically any app that meets the criteria for security and otherwise to do so. They are continuing to answer standardization questions. What is certified API? They're working with those developers to help them become standardized and to help create that sort of consistency and approach, so we don't have all these different criteria where EHR vendor A is saying, well, EHR vendor B has different fields and different interoperability standards, and so they either can't or won't connect to us or whatever. We cannot match these things up. That push for standardization and helping developers figure out how to standardize those things so this can happen is a big impact on those IT developers. And certainly there's going to be a shakeout. For one reason or another, there are going to be certain EHR vendors that either are not poised to be able to meet those standardized standards or otherwise, and so they could fall off, with most hospitals now transitioning to the big ones, the big AHR developers. That shouldn't be as an issue, but I certainly deal with smaller groups, whether it be physician groups and others who've been sort of on the, I don't want to say fringes, but off the mainstream in terms of what EHR. We could definitely see a shakeout as that standardization happens, and some of those fall off because they are simply not able to create those, meet those standard criteria through further innovation of their particular software systems and EHR platforms as they are currently configured. And then, the last impact on IT developers that you as healthcare providers are going to experience indirectly is as they continue to meet the rollout requirements and that standardization and all that sort of thing. Like I had mentioned with the FHIR standards and the API and whatnot, you're going to continue to be the indirect. You're going to continue to experience the indirect effect of that, and hopefully, with the hospital systems that I'm working with, a number of them with regard to information blocking in particular have put together small work groups that meet on some regular basis. And more often than not, they are including their IT representatives in that process, so they understand that there is a coordination of efforts there. So they keep the IT developers, their EHR vendor, included in the process, so they can begin to synchronize and continue to synchronize how internal hospital processes that you've had for decades with your HIM, and how typically requests come in, and you've controlled that sort of release of information in a very guarded fashion, and rightfully so with regard to confidentiality, that begins to transition, and the thought process begins to migrate towards how do we do this now that the IT vendors are moving to an automated process. How do we still ensure security? How do we ensure that we don't expose our systems and so forth? And the IT vendors they have an aligned interest in that. So it's not like you're on your own, and at least the work groups that I've worked with, the IT vendors and the healthcare provider interests are often aligned. Nobody wants to compromise security and so forth. And so that sort of coordination of effort is highly encouraged in your own systems as you move through, particularly when we start to become more and more automated. The time to figure out how to deal with FHIR standards and whether what's actually happening and how you got to transition off of your prior processes and policies with regard to how HIM used to manage that has to start happening now, not December 31st, 2023, when the FHIR standards go into place. That you really need to start thinking about, because there is, quite frankly, again, from the work groups that I've worked with, there is somewhat of a disruption of the process, and the people who have been there sometimes for a long period of time and are accustomed to doing things a certain way need to be re-educated, and there's and that takes time. That takes time to accept the issues and to have them really integrated and folded into that process, so they feel that they are also a stakeholder in that process and they understand how that's all going to work out. Okay, so with that, just real quick information, just to rehash, right? This is a regulatory defined standard now. I'm sure many of you, if not all of you on this call, already know that. The citation is provided here for you. I have done 6-hour webinars on this alone with regard to what constitutes information blocking. There are so many nuances of this, as I'm sure many of you who've worked through a number of use cases already know. This, in conjunction with the exceptions and how to operationalize exceptions, certainly present challenges. But for today's purposes, in terms of understanding as of October 20 of this year, October 6, 2022, how this is going to change for you in terms of your conceptualization of what information is subject to this rule. The definition of what is blocking remains the same. So to the extent that you have processed or worked through a number of those use cases and what is not information blocking, again, this is happening or should be happening in a very coordinated and cooperative process aligned with your EHR vendor. The definition essentially is, almost any practice that can interfere with or is likely to interfere with access, exchange, or use of electronic health information. And of course, that's confined to only certain types of actors. Either the health IT developer has to engage in that practice, or an HIE, HIN, or a healthcare provider that is part of Medicare, Medicaid with regard to that practice. And so those are the actors, and that's the broad definition of information blocking under the regulatory provision. here bringing this up, you can see that October 6, 2022 transition. I had mentioned already that the applicability date or that effective date of the information blocking rule has already come and gone. That effective date, as I'm sure you're well aware, was April of last year. And so we continued, and during this period, you were at least required from a legal sense to be responsive to requests for EHI, but only with regard to the subset, which is referred to as USCDI data, and which is what some of the focus of today's discussion is. And so that subset of those that have looked at it and those who are transitioning, again, something that is, I'm sure, happening a very cooperative process that you're feeling the indirect impact of at a minimum as the EHR vendors migrate to USCDI and off of CCDA, which is Harm's going to go into. You are only required to track that which the HIT vendors were really doing. In some cases, they're able to voluntarily, they've already are sort of ahead of the game. In some cases, they are not. But the bottom line is that up until that regulatory deadline date of October 6, 2021, you are only required to be responsive to a request with that USCDI subset. One practical impact of that has been that if you are only required to respond with USCDI data and the request has been for the entire EHI data set, you were able to, yes, I'm sorry, is there a question?
Can anybody hear Helen?
Yeah. Yes, Harm, did you want to interject here? Okay, I'm just going to continue. Okay, so one of the impacts of that with regard to the information blocking regulation piece is that you are only, with regard to information blocking, are only required to respond with regard to USCDI data, to the point where if you're not able to segregate the USCDI data from the entire EHI data set, ONC has said, well, you can actually claim a certain exception of not able to technologically segregate that data, and you're simply just not required to meet that criteria if you're not technologically able to do so. So there was a lot more latitude in terms of potentially claiming exceptions during this period of time, which are essentially going to go away as of October 6, 2022 in a few months, which is going to then remove that restriction to just USCDI. And now we're going to, if a requester asks for a copy of the entire electronic health information that they're otherwise permitted to get a copy of under applicable laws, then you need to produce the entire EHI that they are requesting. So it's important to understand that how EHI is defined for purposes of the information blocking rule. There is quite a bit of overlap with the HIPAA definitions that you can see here. It does track that EHI is essentially electronic protected health information, but it is regardless of whether or not that electronic health information is maintained by or for a covered entity. So it's not confined, it's broader in that sense in terms of who is holding that data. We're really looking at actors, and actors are slightly different than covered entities, right? So they're saying it was not confined to just covered entities, it's really confined to the definition of actors, which are those three categories: HIE, HINs, providers, certified health IT developers, and of course it carves out, similar to HIPAA, the psychotherapy notes and that information compiled in reasonable anticipation of civil, criminal, administrative action or proceeding. This snapshot on the next is straight from ONC. This provides a really nice, I think, sort of a Venn diagram, if you will, of how there are subsets of subsets. So you can see the largest block here. They take the definition of protected health information, which is the broadest, right, and which we're most accustomed to with regard to HIPAA and defining what that is. And it also, of course, you can see in the right piece that, PHI, of course, includes paper portions. It also includes oral, spoken versions. You can violate HIPAA and protected health information disclosures by orally disclosing it. So that's the largest subset. And then within HIPAA, of course, you have electronic PHI, which, of course, the security rule only applies to such PHI that's in electronic format. And now we get down to how that overlays in that Venn diagram with the information blocking rule. And of course, you can see, if you go first actually down to the lowest block, you can see before October 6th of this year, that EHI and that definition was, as I've mentioned already, reduced down to limited to only having to comply with requests for data that is confined to what is the US CDI defined data sets. And then, of course, after October 6, 2022, for purposes of information blocking, that will now expand to EHI, all ePHI that's maintained in the designated record set, which essentially works in tandem and very similar to how patient access requests and certain patient rights are also how they work under the HIPAA rights section for patients. But this, of course, is expanded beyond just patient requests. It's all requests that may go to an actor requesting for EHI. So it could be, just to give a very vivid example, it could be a request from a researcher. It could be requests like I did an entire white paper on organ procurement organizations that want to connect an app to an EHR now, and rather having send their representatives in to get that vital data upon the immediate expiration of a patient, so they can preserve those organs and get a sort of a scope of whether the person is an appropriate or matched donor. They can do that quicker with an API and an app connection to the EMR. And so, so when we talk about information blocking and all ePHI and a designated record set, yes, we are talking about requests that are coming in from patients and their personal representatives, but we're also talking about requests that are coming in from other types of requesters, like the examples I just gave. But with regard to what data they can get on, the definition overlaps with the same kind of ePHI that's in a designated record set for a particular patient. Okay. So a couple of FAQs before I turn it back over to Harm that I thought were on point and relevant for our discussion today. The FAQs, the ONC is constantly updating those FAQs. I believe the most recent of which were put up around February of this year. There were one or two added, I think, and one of them I think is on here. So I pulled a couple that deal with US CDI and requests that I'd like to just touch on and go over with you so you have those familiar with those. So FAQ 16 says, what if I don't have the IT yet? What if the IT is not required as a condition of certification, or simply the IT does not support, all right? So it not support what the requester is asking me for. So for the period of time when information blocking rules is limited to the US CDI, how are you as an actor expected to fulfill a request for the US CDI if they do not yet have the certified health IT in place that includes an API with the US CDI standard that allows you to respond to the requester in the manner requested? Okay, so, and the answer, and I had alluded to it earlier, that you are permitted to limit it. You are tied as a provider in particular to what your IT is capable of doing. If your IT is capable of supporting it, if the IT is there, it's already configured to support that response to the request, then you don't have that exception to rely on. But if your IT is not ready yet, it hasn't been standardized yet, or it hasn't, because your EHR vendor is not there yet and is not required to be there yet with regard to the certification criteria that's on the top part of that flow chart that Harm had up there, then you essentially can't meet that request if your IT can't support it. And you can claim the technological infeasibility exception, but then you do also have to ask whether, the content and manner, you have to go to other means and other ways, whether you can export the data and satisfy the requester in a different manner. If you can't do it through an API connection, can you produce that electronic health information in another way that satisfies the requester? And that could be that hierarchy. Of course, I'm not going through the exceptions today, but those have looked at that, I'm sure are familiar with it. FAQ 21 I thought was really important to touch on because they responded to the repeated question of, do I have to share all of the EHI? And the questions that were coming in are, do you as a healthcare provider, are you required to fulfill a request for access to change and use of EHI with all of the EHI you have for a patient, or is the amount should be based on the details of the request? In addition, what if an actor only maintains some of the requested information electronically? And bottom line is that you do not have to spill your guts. You don't have to give them the entire kitchen sink if somebody's only asked for a fork. If they've asked for a fork, you produce the fork, provided that your IT is technologically able to just produce the fork. If they are not able to segregate the fork from the kitchen sink, then you have a choice. You can either claim segregation exception and then go to content and manner and see if you can satisfy the request in some other way, or you can voluntarily choose to give them, be like, hey, I can't give you the fork, but I'll give you the kitchen sink, and you can voluntarily give them the kitchen sink. Now you're going to ask me whether minimum necessary is violated. It depends on who the requester is, right? So you can potentially give providers the kitchen sink, even if they're asking for the fork. Of course, patients, there's no harm, no foul, giving the patient the entire EHI, even if they're requesting for only a certain data class. But there are other requesters that are requesting things potentially for other purposes like research or certain healthcare operations that you could and need to be mindful of minimum necessary, and so that you may be able to rely on things like segregation and exceptions and technological feasibility to not have to produce the requested EHI. All right, what else do I have to share after 10.6.22 FAQ 39? This just reiterates what I've said, that on and after October of this year, what you need to produce can apply to the full scope of EHI. So if a requester is asking you for the entire EHI on a patient or patients, and there are no other exceptions or legal barriers to doing so, then essentially you could and need to be mindful that you could be engaged in information blocking if you're not allowing that to proceed forward and be responsive. How about complying with other laws? Could you be in violation of information blocking if a particular law requires you to share certain EHI and you choose not to comply with that law? And can that, in addition to violating whatever that law may be, can that also implicate information blocking? And ONC says, yes, it can. In fact, they gave us 2 such examples that you can basically get double jeopardy, if you will, for legal talk. ADT notifications, I know that a number of you are probably working on this. This is the required CMS condition of participation. The patient access final rule, it requires hospitals to send certain electronic patient event notifications to their PCP and others when they've been transferred or admitted or discharged. And so your failure to do that could not only implicate that COP, it could also trip you up for information blocking. Another example they gave is public health reporting. If your state laws require you to submit or to report certain EHI to public health authorities, and you purposefully do not do so, even though you're technologically capable of doing so, again, not only could that potentially implicate the public health reporting laws under state law, ONC saying, hey, not only that, double jeopardy potentially, you could also be tripping up, and we might be able to get you after, you might be implicating information blocking violations. So what impact to me? What do I care? I don't see anybody, like with HIPAA, it took a few years to get going on this. There is no enforcement yet. There is a whole bunch of reporting that's happening though. This data was posted, and you can see here the link. You can go look for yourselves. People are, there are stakeholders that are reporting potential violations of information blocking, and this data is showing that, look, since April 5th, 2021 through May 31st of this year, they've received a total of 413 complaints of information blocking. I'm sorry, the total number of submissions is 413. Of those, ONC has flagged 381 of those as potential information blocking, and there were 32 that did not appear to be claims of potential information blocking based on their assessment. You can see the types of people who are complaining. On the right-hand side, you can see patients, third parties on behalf of patients, healthcare providers, attorneys, unknown, IT developers, HINs, and then down below the types of actors. Again, healthcare providers are by far the highest number of types of complainants that are submitting claims of information blocking against other types of actors. And then IT developers as a second, and then it goes down the line. So enforcement, real quick, again, here's a scope of how enforcement will happen. We don't have a final enforcement rule for providers yet. So there is no way that they can assess whatever financial or other disincentives they're going to lodge against you. There is an enforcement proposed rule for HIE, HIN developers, as well as HIE, HINs and health IT developers, but that's not in final form. But just understand that, that is in the works. There is going to be enforcement, and those complaints are coming in. And so I know that ONC is aggregating that data, and, last thing you want to do is end up on their radar. Okay, with that, I'm going to turn it over to Harm, and he can touch on the more IT aspect of this.
Helen, thank you. That was a lot of information. Just a quick check, can you hear me, Helen?
Yep.
All right, good. I had some microphone issues earlier. So thanks, everybody. And before I start, if you have a question, please type in the question box, and one of us will read it, and we'll incorporate that into our talk. Also, maybe we'll have questions at the end, so please feel free to enter your question, and either Helen or myself will try to answer it. Helen discussed the bottom of the chart, mostly information blocking. I will now speak about the certification rules, which are also, there's a deadline coming for certification, which will also affect us as providers. And you'll see there at the top, 12/31/2022, so December 31st of this year, new HL7 Fire API capability and other Cures update criteria. One of those other ones are that the US CDI, the United States Core Data for Interoperability, will replace the CCDS for, let's go to the next slide for that. I think it's on the next slide. There you go. So the deadline by the 31st December is that US CDI version 1 will replace CCDS. CCDS is the core clinical data set. It used to be that CCDS, which is a much smaller data set than US CDI, that CCDS was the set of notes providers were expected to exchange to each other, basically saying these are the contents of your CCD, your continuity of care documents. And that will now switch to US CDI. And the difference is on the right side, you'll see the map of the US CDI. They are in many ways similar to CCDS, but the big difference is that US CDI includes lots of clinical notes. Third box on the left side, clinical notes. So it includes consult notes, discharge summary, H&Ps, imaging, lab reports, pathology, procedure notes, progress notes. Progress notes, of course, strikes me as a big bucket of notes. There are multiple progress notes for each hospital admission. So this implies that progress notes should be part of the data you share under US CDI. In most cases, up until now, CCDs would include the discharge note or the visit note, but not that entire list of notes that you see there. So we should expect that this means that providers are expected to share many more clinical notes than they were before. And that is an impact that's going to happen at the end of this year. This is a certification requirement. So in other words, this says your software developer, your EHR company needs to be able to do this. It doesn't specifically say, and therefore you as provider organization, you must also do it. It says this is required for the EHR vendor, not necessarily for the provider. But we'll talk about this in a second. I think in many ways, once the vendor puts it in place and patients and other people can ask for it, we might as well put the information in, because it should be able to be shared. This is US CDI. Let's go to the next slide, Helen. So here's three questions that we will talk about. One is, in the past, your CCDs or CCDA documents would include the key fields in the smaller core clinical data set. Will they now include all of the US CDI fields? From an EHR vendor perspective, from an Epic and Cerner perspective, yes. The software should be able to include all those data elements into a CCD or into a CCDA document. From a provider perspective, while it's not prescribed specifically by this rule, because it affects the EHR vendor, not the provider, It's definitely not prescribed, but it's most likely probably should be, yes, because those fields now should be able to be shared in a CCD. Therefore, in my second bullet there, second big bullet, my expectation is, and this is especially relevant for an organization like HSX, Healthcare Exchange, where we do exchange a lot of CCDs. We receive a lot of CCDs from our members. We also send a lot of CCDs to our members. So CCD documents, when they start including all those US CDI data fields, will become much larger than they are today. So that creates, on the one hand, it's a benefit because we're sharing a lot more data, but it creates a usability concern. It makes it more difficult to navigate, to manage, to find what you're looking for in those very large CCDAs. And there are some solutions for that. One of them is what I mentioned there, is you might be able to consider creating multiple CCDA documents. In other words, you might say, I'm going to create a CCD that is basically a full copy of the record, the entire transition data set, or the entire full data set, or I might also at the same time create a much smaller CCD that includes only the key fields for a transition. It's possible. I'm not sure how many vendors and how many providers are going that route to create multiple different CCDA documents, but that's certainly a possibility to make it more manageable to have these large fields. The other one, Helen, I want to briefly switch to the next slide and I'll come back to this one if you can. So the other option that I see in terms of usability is that we should start much more using the search function. Most EMRs today have a search function. They require you to target search what you're looking for rather than browse through an entire set of data. In HSX, we are close to upgrading to our next version of our portal, and it's called HDH, Health Data Hub, Next Gen Health Data Hub, and it will include a search function. So I believe that by including a search function in both the EHR and also in our HSX user interface, it will make it much easier for users to type in what they're looking for and find it rather than having to go through entire CCD documents, which many users do today, but they will become just too big. So I believe search is becoming a big usability feature, and we need to start enabling that wherever possible. Whenever we see it in our software, we need to enable it, and we need to train our users that is probably a faster way. I don't think users need a lot of education in searching because we live by search every day. You know, all of us, we research things every day, all the time. So I think once people figure out that same search capability lives inside your EHR and lives inside your health information exchange, it's going to be a quick transition to start using it. Helen, let's go back if you don't mind. My third point there is we need to think about physician and provider awareness. As we transition from sharing the information we do today to the US CDI, there again is an increase in the amount of information and the amount of data that we share with other providers and with patients. And I think it's important that we explain to our colleagues, our physicians, our nurses, our clinicians, that there's a step up in the amount of data and information that will be shared, including these progress notes, procedure notes. Imagine, procedure notes are super important, but I don't know that all surgeons and procedure people are used to having the direct notes shared with the patient. So I think another round of training and awareness to our providers is important when we move into that step where more notes become immediately shared electronically with other providers and with patients. Helen, one forward, please, and maybe one more forward. There we go. So I put this slide in because it's so far with Helen's introduction and with my introduction, these are all very regulatory, government-imposed initiatives. And what I'm also hoping is that we, as providers, see the Cures Act as a strategic opportunity. For example, meaningful use was an enormous wave, and most of us saw it as a government-imposed set of requirements, but it also created lots of opportunities to activate patients, to share data with patients, to move our electronic health records forward, to move our own data infrastructure forward. So I'm looking for ways that we could say these two big new deadlines in the Cures Act need to be also strategic opportunities for us and for organizations. So first of all, I think that we should use them to encourage patient engagement and to use digital tools. These Cures Act rules make it a requirement to open up our FHIR APIs to anyone with an app. I don't know that if I have it in the next slide. I was thinking I might have skipped one slide here. Alan, can we go on forward? No, it's not. Never mind. I will speak. Let's go back and I will speak to it there. I thought the one topic that I was going to make but didn't make yet is the other requirement, not just US CDI, is the fact that we will now have to support FHIR APIs to anyone who wants access to the information. So that means we should expect parties to approach us as providers to say, I would like to connect with my API to your data set. I don't quite know what that will be, but most likely I'm thinking it will be personal health records. It will be applications that retrieve data for patients, on behalf of their personal health record. We've heard about personal health records a lot before. And if you Google personal health record, you find lots and lots of names, none of which you've ever heard of before. So there are many initiatives of personal health records that are other than Apple Health, quite unknown, not very widely used, and kind of under the surface. And I believe that this set of Cures Act rules, these opening up of FHIR APIs, will give another boost to these personal health record services to say, now is our time to connect to EHRs and start retrieving the data. And to me, that should be, I'm hoping it will be, a patient engagement wave. It will allow patients to more directly interact with their data, and it allows us to provide digital health tools that create this quote unquote minimal effort, which is, as it's described in the law, that minimal effort to access your health information, right? That was one of the requirements in the Cures Act, to provide patients with their data at minimal effort. And I think that's what we should see as the strategic opportunity to actually make that happen. I would encourage, therefore, everyone to fully deploy your EHR's API capabilities. But all the large EHR vendors will have, at this point, mostly read-only API capabilities. I would like to see health systems and also HSX to deploy that so that we can start interacting and exchanging data more. I also think a role for CMIOs and for clinician leaders, health IT leaders in organizations, is to really emphasize the availability of what I call outside data to your clinicians. These interoperability rules and next set of deadlines make it even easier to retrieve data from outside organizations. We are very used to looking at our own EHR only. So I'm hoping that by this set of rules that we encourage our users to say, start using your health information exchange. In our case, HSX, start grabbing data from HSX, because there's a lot of data that is not in your electronic health record that comes from outside. Through HSX, start looking at P3N or the New Jersey Health Information Network or the Delaware Health Information Network, because they also are health exchange networks that provide data from outside. And then on top of that, of course, you have access to Health Exchange, eHealth Exchange, and Commonwealth and Care Equality. So I see these set of as concentric circles of outside data. First HSX, Healthcare Exchange, then the state networks, from there the national networks, in case you need to find outside data, on top of what your vendors provide. So I'm really looking at this as an emphasis on improving the workflow to access outside data. Alan, next, please. Which is, and this is a recap of a slide that Helen had earlier, what this means for clinicians and for hospitals. And I will just restate those 4 elements. Making patient data requests easy and inexpensive. The minimal effort is the line they use, line ONC uses. Minimal effort on behalf of the patient or behalf of the organization to provide this data electronically. I see that, 1, as a government mandate, but 2, as a strategic opportunity. Allowing a choice of apps, or you might say encouraging a choice of apps, right? Having a variety of apps that allow patients to get to their data. Apple Health, but I can see a huge amount of apps sitting out there, but not widely used today. And I think they may be waiting for this API availability to really take off. And I think we should get ready for that. I think as health organizations, we should be ready and prepared to support the APIs and app requests that we'll be getting. Implementation, obviously, of more tools and more interoperability methods. And finally, improving patient safety. That, of course, has been an ongoing effort starting at meaningful use. I think interoperability is more than patient safety. Certainly, patient safety is part of it, but I think it's much more that left side, making patient data requests easy and inexpensive. Next one, Helen, please. Before we do the recap, Helen wanted to discuss a couple updates on which version, because there is, as you heard, a little bit of confusion about US CDI version 1 or 2. And Helen, maybe you want to jump in and speak what version users should be aiming for?
Yeah, so I put this up here, Harm, because you and I had some robust discussions about the versioning and you know, what applies when and all sort of thing, and how there may be some disconnect with regard to the version that's in fact for information blocking rule on the bottom part of that flow chart versus the certification criteria, and there's a lag and all that sort of thing. So I recommend this really wonderful PowerPoint, quite frankly, that ONC put together on this topic that I think provides ample guidance on how those versioning, the US CDI standards are work, and how a number of them are voluntary and all sort of thing, and when they're mandatory and so forth. So, I mean, just recall, for purposes of information blocking rule, this whole point of US CDI, quite frankly, goes away in a few months. So with regard to what information has to be produced in response to a request for EHI, it will no longer be relevant which version of US CDI may or may not be implemented. But it's still worth taking a look at, because it will impact things where, for example, you might be required under other kinds of programs to produce CCDAs or whatnot, or where requests come in, and those will be mapped more closely, I think, to the US CDI standard. So I have pulled up a number of the FAQs that were contained in that PowerPoint. Again, I have here, and you can go straight to this, to the entire PowerPoint that's posted on ONC's website. But I pulled just a few of the slides that were contained in that PowerPoint towards the end, where ONC provided very specific answers to questions that were anticipated or popping up. These are not, interestingly, posted yet on the FAQ website. Maybe they felt like they were too specific to the certification and technical criteria and don't have enough applicability to information blocking rules. So, but they're contained here. So, for example, this first question with regard to mapping clinical notes, and this sort of gets techie, Harm, and it's sort of in your realm more. Those who are on, who may be more compliance driven, whose eyes may glaze over a bit like mine when it starts talking about this stuff. But for those who are on, who are IT driven, it probably makes a lot more sense. So I could just read it real quickly. I mean, we have about 10 more minutes. I do want to leave some time for any questions.
Yeah, there's a question on the board, but we can maybe spend months. Well, this is quite a technical issue here that you have here, Alan, and the background. I don't know if you know this. The background is that the US CDI specifically gives us 8 LOIN codes for clinical notes. 8 codes. Where if you look at the LOIN database, there's many more notes codes available, but they only gave us 8, and people are confused about this. Should we only use those 8, or can we use other LOIN codes? And I think the answer here is you can use the other LOIN codes and be much more granular than US CDI makes it look. I think that's the background here behind it.
Yeah, and I just want to point out, if you go to the last statement that they have in their slide here, important reminder, right? Just what I just said, regardless of the decision to map notes to US CDI clinical notes data elements, after October of this year, the actor must respond to a request for access to change the use of EHI that meets the broader EHI division, and the limitation to EHI no longer to only content of UCM no longer applies. So they're basically reminding you, look, to the extent that this applies for the other certification or meaningful use or whatever other programs and other sort of interoperability that you may be following and need to follow, with regard to information blocking rule, this no longer is an issue. And remember, you have to produce all the EHI that you are technically able to do. There's this Harm. There's this question that came up and that they responded to, whether you will be required to update your certified health IT module to USCDI, and it's saying here that as of right now, no. Once it's updated in January to the USC is included in approved standards for 2021, they will be able to update it to a new approved version of UCDI within the scope of certification criteria without having to retest and recertify, and seeking to obtain initial certification for the health IT module will be permitted to certify directly to a newer version approved under SVAP. I don't even know what that is. So, but I mean, to me, Harm, correct me, this is a phased approach that during a point where it's not in effect, it looks like it's going to be voluntary, but as the certification criteria moves towards FHIR, then it becomes, that requirement comes probably next year. So this is sort of a transition that IT vendors will slowly be working to and implementing those on a rolling basis to be able to work up ultimately to that full scope of data that would be made available, unless I'm mistaken on that.
I think you're right.
Yeah. Okay. There's a couple of more slides here. I actually, maybe leave that to the audience to go through.
I would like to ask you the question that came up on the board, because it's an interesting question and it's not in your slide. So the question was prompted by me, but it's going to you, Helen. The question is, who will be liable for a breach in the transfer of a patient's information to the patient via one of the personal apps? So a patient is using an app that uses an API that retrieves my data. Who will be liable for a breach in that transfer? Is that something you have thought about, Alan?
And certainly in other contexts, this question has already been implicated. A few years ago, there were many providers that became concerned as HHS and OCR, which enforces the HIPAA provisions, and particularly turn their focus on providers not fulfilling requests by patients and their legal representatives, personal representatives, to access their data, and were denying it on various grounds, and security being one of them. And HHS, took that up, if you will, because their push and their position was that they wanted the patient to be able to be in the position of control to decide whether or not they were willing to accept a risk of the manner in which they are requesting that their PHI, and specifically their ePHI, be provided to them from a covered entity. So for example, historically, and while this was sort of shaking out, HHS essentially issued I can't remember if it was a guidance provision or an FAQ per se, but the guidance was the same, or the position was the same. And they basically said, you covered entity or whomever needs to comply with the patient access provisions and the right of access. If a patient asks you that they want a copy of their EHI, and for example, they are demanding that you send that ePHI to their Google Gmail address, and your internal policies have would generally prohibit that, because everybody knows that Google, unless it's configured specifically under its HIPAA, BAA, as a general rule of thumb, particularly the free accounts, are not encrypted and are not necessarily foolproof against breaches, as you will, security breaches, security standards, and whatnot, and could be vulnerable for third-party access. There might not be the necessary authentication or verification of identity elements. Somebody could set up a Google Gmail and say that they are somebody who they're not, and you're not necessarily verifying it. So there are concerns, but HHS was clear on this. They said, look, if not to say that you shouldn't do some level of verification, because I do think you have that duty, but the reason that a Gmail account or an email is not by standards, industry standards, secure per se, cannot be a basis upon which a covered entity refuses to provide the patient a copy of their requested EPHI when they otherwise have the legal right to get access to it. They took a very clear position that patients' right to control the way in which they get their information would override any possible concerns. Most importantly, and directly to answer your question, Harm, they did state that if a breach were to occur in the process of that transmission and the patient accepted those risks up front, then the provider who is releasing that information in that potentially unsecure manner would not be liable or would not be found to have violated security breach and security standards by releasing that information in that manner. So now translate that to the API and to the app world. HHS, well, I should say particularly ONC, and interestingly, the FTC, the Federal Trade Commission, is sort of getting into the space with regard to trying to control predatory apps. But the same sort of policy, if you will, applies in that, their position is that a patient chooses the app and the app of their choice, and if they want you to connect to such and such app, it's not your right to tell them yes or no. Now, with that, ONC did say education about certain apps, educating patients about, things that they should be aware of with regard to security and things that maybe they want to be mindful of when they're selecting their apps, because there will certainly be predatory apps out there, companies who are simply trying to get at patients' information and are going to be abusing this process to unwitting patients who don't really understand, or individuals who don't fully understand the security measures. So ONC did say that education process that occurs for patients would not be considered interference. You can educate patients. My understanding is that in the near future, that the APIs and the connections with the apps would have potentially some automated process of asking the app whether it connected or has certain criteria. This was actually in the preamble to the information blocking rule. It has certain criteria present with regard to your privacy practices and security practices. And so if they say, for example, that your EHR is going to list out 10 to 15 criteria, if it matches the app, that's considered secure. If it doesn't match the app in security and privacy, then you can tell the patient, hey, your app is sort of falling below here. That still doesn't give you a reason not to release it, but you would not be responsible for that so long as the patient is informed and accepts that risk.
All right, Helen.
Yeah.
Carol, you could not ask for a more thorough answer. I appreciate the question. We're at the end of the hour. Helen, could you move us forward to the very, very quick recap?
Yes, the recap.
Quick summary. And
let's do it.
Carol, I'm afraid I will have to look at your question. So we're at the top of the hour, at the end of the webinar. I really thank you all for attending. The two big deadlines clearly coming up is October 22nd, information blocking scope will expand to the full EHI. December 22nd, December 2022, the US CDI will, which means more information in the CCDs, more information in the FHIR APIs. So, and my request and my desire is that we can all look for regulatory compliance and look at that as in a strategic way. So we provide strategic plans to digital health and patient activation. I want to very much thank Helen for her participation in this webinar. If you have any further questions, please follow up with us through HSX. And this was another session of HSX University. I hope you find it helpful and useful. Thank you everybody for attending. Thank you, Helen.
Thank you.
Fatima, will you stop?